I'm Alex Howard.
And I'm Amanda Silver, and this is Dirty Laundry. And today, we have Maryam Manteghi from Manteghi Law. I am so excited to have her on. I've been following her for a while.
Yep.
She has such great information.
She's brilliant.
She's really helping women.
Yeah, she's fighting the good fight.
She really is fighting
Yeah.
the good fight. She's all over the world. She's working for the United Nations. She's helping, women who are victims of domestic violence. And she's really pushing forward their voices.
Mhm.
And she's coming on today to talk about coercive control, family violence, the changes that are happening within the court systems, the changes that need to happen, and what you need to know if you are a victim, how to present it so that you're believed, because a lot of people are not believed.
Yeah.
So welcome, Maryam.
First, before we get into all of that fun stuff, where are you calling from then if you're not in Canada?
I'm in Sarajevo, Bosnia and Herzegovina.
Oh, wow. You're the first guest to ever zoom in from there.
Yes. And why?
Yeah, I'm currently here. Yeah.
Okay. What are you doing there? Working or just a pleasure cruise?
No, I mean, I kind of go from, I'm here and I'm in Amsterdam and I'm in Oakville. So Toronto,
Okay. Yeah.
Nobody knows where Oakville is. So
I've got you.
But I kind of go between these places. I used to work here in Bosnia for the United Nations High Commissioner for Refugees. I worked here for 6 years for various UN agencies. And I loved it. I love being of service to people here. And one of the really exciting things happening here now is that there's a new law on femicide, which
amazing.
is so much more. It's really so much more of it's a much more progressive law than we have anywhere than we have in Canada.
Wow.
It's criminal code law for them, right? And so it's very exciting that there's this new law on femicide, but so legally they're like way ahead, but in terms of like implementation, kind of we're way ahead in terms of the stigma of domestic violence, in terms of institutions being alive to domestic violence and reacting to different, and a lot of that obviously has to do with like financial means of the infrastructure and the country. But yeah, it's great. It's great that this little country has this. This feminist, it's terrible that they need it, but it's great that
we do need it.
There's this law that's such it's a law we could use.
I was going to say, tell us.
Tell us about this law.
So Bosnia and Herzegovina has very recently in the last, I think it would be in the last 6 months, they have adopted new criminal law called the Law Against Femicide. And one of the things, for example, that is superior to our criminal law is that it's much easier to get a restraining order against your abuser than it is in Canada.
Like a lower burden of proof sort of thing, or?
Yeah. So it's easier in the sense that when you go to the police station to, usually when someone, very rarely do people call here to call in unless it's very serious. What generally happens is that somebody will, a victim will experience violence, and then at a point afterwards they'll go to the police station and they will they'll report it, right? And in Canada, when that happens, when it's not immediate, right, there's always more questions, right? Like, why didn't you call right away?
Right.
There's always these questions. When you go and you report it in Canada, you may not always get the abuser being charged. And I find with the law here, it's easier. The law facilitates charging the abuser so that there can be a restraining order put on the against the abuser, protecting the victim. Now, the difference here, obviously, is that there's a lot less economic structure, economic framework, so that, for example, the abuser doesn't have anywhere to go. They don't have money to go to a hotel. It's not like that here, right? And then the abuser, if they're working and the victim is not working, like if he doesn't pay for whatever expenses, the mortgage, the rent, the bills, she'll get kicked in. So there's a lot of, it's the support systems, the infrastructure around support systems that's missing here, but the law is really good. We have the support structure that is there socially, but the law for us has become a little bit tainted by this question of, is it always the woman? Right? This is kind of the daddy's rights, the father's rights movement in family court that has kind of seeped into everyone's minds. Whereas here it's that's not so much of an issue.
It's so, and how those, and while yes, our country is very progressive in dad's rights, father's rights, it's almost gotten so much to the other side where women who are potential, statistically, it is women who are victims of domestic violence. We know that, are then being, their claims are being dismissed because the pendulum has swung so far. Yeah.
Right. One of the, and I speak about this on my Instagram page because I think it's really important. And that is two things. Thing number one, or issue number one is that there's a lot of what we call, and I don't like to call it that, but because people recognize it by this term, it's called reactive abuse. I call it, and it's been called, I didn't coin this term, but provoke and record, provoke and document, right? So I have a lot of clients where that's been something that's happened. So they have been provoked by the abuser, and you're not in a state of, especially postpartum, right? They've been provoked by the abuser postpartum. And obviously postpartum is the most vulnerable time for a woman. And when she, just biologically is at her most protective. So she's at her most vulnerable and also at her most protective. And it's the easiest time for an abuser to be able to, exploit that situation. And we have a lot of that kind of abuse going on. And actually, that was one of my first COVID cases where I had a woman who had been provoked and recorded, and she lost her almost year-old baby, and it took about almost a year and a half to get the baby back. And there were a lot of things wrong in that scenario, which was also a judge that had absolutely no background in family law and no background in any kind of law that wasn't just paper based.
Right.
So that's, also a concern in family court. But yeah, I mean, this kind of recording, right? Recording you when you've least expected it. I work with a private investigator, and I honestly don't know how I worked without her.
Amazing.
I don't know what I was doing before I had a private investigator, like how I actually was able to amass evidence.
That's amazing.
But
we've heard about individuals hiring a PI, but never for a business. But that's brilliant.
And how do you work with her? What does she offer you?
So, she offers my clients, right? And then through, obviously we collaborate on what I need and what she's going to get. But one of the things that has become very common is abusers having, leaving the home. There's a separation, but the abusers have left some kind of recording device, audio recording, video recording, both inside the home. And I think the last time I spoke to her, she was so concerned. She said, I can't believe it. Every home I've swept in the last month has had a device.
Oh my God.
And it's interesting because I think a lot of women can't believe it.
We can't believe it.
And we work in this industry, and I work in high conflict, and I'm just like, I don't even think to tell my clients to go get their house swept, but I probably should.
Oh my goodness.
Well, I also have clients who come to me and say, oh, we went to court and he knew everything that I was going to say. He knew it's like he knew exactly what I told my lawyer. It's like he had listened to this conversation with my mother that came in. It's like and I say, have you had your house swept? And they look at me like,
shit.
and I'd say, okay, we
Oh
need
my
to get
God.
your house
Yeah.
swept. And every single time, I mean, obviously I work with a very niche
Yeah.
clientele,
Yeah.
but
Certain
every single
personalities.
time
Is
where I've had that suspicion,
true.
that's actually been the case.
And
Wow.
is that because it's not, correct me if I'm wrong, it's not typically illegal to put a recording device if it's your own home?
Um,
Like,
it's not illegal to put a recording a device in your own
right.
home because generally speaking, both of you are living in
Yes.
that home and it's a
Mhm.
security, it's a ring light outside the
Right.
front door,
Right.
the back door, whatever, right?
Yeah.
But once it is so once it becomes something that is a post separation incident and was never there as part of
Mm.
before the situation, because who's gonna rob you from out of your bedroom,
Yeah.
Right.
right?
Exactly.
Like you'd rather catch them at the door
Yeah.
than
Yeah.
catching them in your bedroom, kind of thing,
Yes.
right? So what I think the issue is that this kind of listing devices inside the home after separation is one of the incidents in a pattern of coercive
Yeah.
control,
Yeah.
right?
Mhm.
And that's where it becomes important in family law, and also if coercive control becomes criminalized.
Yeah.
But I don't think that in and of itself can be in any way, shape, or form considered a crime. But I
Mm.
think that within a pattern of
Mhm.
behavior,
Right.
I think it can be tantamount to stalking,
Yeah.
Mm.
Right. Yeah.
right? It can
Yeah.
be because it's even worse. Like stalking you,
It's
they can only
worse.
stalk you once you're outside physically, but this is
Yeah.
constant,
Yeah.
right?
Yeah.
Post-separation
Especially not
stalking
knowing.
often looks different than what you typically would
Ooh, let's
see,
talk about
right?
that.
Because I've seen with my own clients, it's, oh, he or she still has access to my email or
Yeah.
my banking or
Mm.
my phone bills. Like they can stalk in
Yeah.
a different
Well,
way.
even something as small as like we share the same Netflix. Now they're looking at what I'm
Yes, so
watching.
there's
Like,
different, and it's very like insidious, and how do you prove this? Like there's these patterns of coercive control that are not in isolation necessarily criminal, but when you put the pattern together, it shows a different picture. But I think that gets missed in family court. It's like unless there's like
Well,
physical abuse and it's on
yeah.
paper and you can see it
Or
and it's
recorded.
recorded or whatever, but like all of those patterns get missed.
The things that seem individually so
Yeah.
inconsequential, yet when you put them together, show of this
This
pattern.
pattern,
Yeah.
yeah.
yeah, definitely. And I think, and this is what my page is all about. It's
Mhm.
education,
Yeah.
Yes.
and I think it's I talk about this, and I talked about this more so after the whole Justin Baldoni, Blake
Mm.
Lively situation, when Justin Baldoni's lawyer came out with a timeline. And that, I don't know if you remember,
Mm.
but he came out with a timeline that was a public record. And well, no matter what you feel, where you lie in
Yeah.
your, what
Beliefs. Yeah.
side you're
Yeah.
on,
Yeah.
whatever.
Yeah.
But the timeline,
Yeah.
I actually posted it on my Instagram page. The way Brian Friedman did this timeline was genius.
Mm.
And I think that when you create every one of my clients needs to create a timeline.
Mm.
Okay?
Hmm.
Every person who is about to go to family court, in family court, at any point in family court, they need to have the timeline of their abusive relationship, because judges are human. And as you can see in the world that we are today, that is such a polarized world,
Yeah.
okay? And oftentimes, you'll hear things where people are taking intellectual positions
Mm.
that are completely informed by their emotions,
Mm-hmm.
right? That it's an intellectual position that wherever it is, I'm not, whatever intellectual position, but it's completely informed by emotion.
Mm.
And judges are no different. And I'm not saying that judges are unable to, d- you know, to separate themselves as a judge from themselves
Mm.
as a person and a human being with their background and their
Their
experiences.
biases, yeah.
But I am saying that, it takes a whole lot of mental, emotional gymnastics to be able to do that.
Yes.
And in my experience, unless those judges are people that have worked out their own emotional, I don't want to say baggage, but their own emotional, whatever it is emotional
Blinders,
that they
yeah.
have, that, yeah, if they haven't worked that out, they're able to see an equitable solution to a
Right.
situation that preserves the rights of everybody in the
Yeah.
situation.
Yeah.
That's rare.
Yeah.
So, because judges most of the time are also informed greatly by their own emotions,
Mm-hmm.
okay, what you need to do is to appeal to not only the intellect, which is the law,
Yeah.
but you need to appeal to their emotions. And you need to trigger in them the kind of emotion uh, that will get you the favorable result that you want. And in this case, the favorable result you want is an understanding of
Yeah.
a pattern of coercive
I
control.
see. I
And the
see.
only way you can do that is through a timeline. You take the hand of that
Right.
judge and you say, let's show you the ghost of year number one of our relationship. Right?
Right.
Let's show you the ghost of year number
Yeah.
two of our relationship.
Yes.
And you walk that judge through
Yeah.
all of the story
Right.
of your relationship.
Mhm.
And it is
Okay.
a story. It's not
Yeah.
just a snapshot. That's always a fear of people who
Yeah.
go to court. It's like they're only so much time to look at the story, right?
Mhm.
Especially if it's like a motion versus a trial. And so the judges are seeing a snapshot
Yeah.
of the current situation without maybe the entire
The
context
whole
of what
picture, yeah.
really happened historically.
And I like that you're talking about leaning into their emotions, but how do we separate that from claims of, oh, women are so hysterical. Oh, women are so emotional. It's like stick to the facts still, but in this almost narrative of the retelling of the story to show that pattern. So you're sort of trying to appeal to their emotions while you yourself, as the client, as the victim, as whomever, not too emotional about that story, right?
Right.
Like that's
It's a
really
thing to juggle.
hard tightrope to walk.
So that's a very interesting point. And I'm going to tell something. I'm going to tell you something as someone who was also a victim of family violence. And that is that once you know that your story has been crystallized to the best of your ability in a timeline that cannot be touched, right? That timeline will be the affidavit that goes
Right.
to your motion to change. It'll be your application. That timeline is the foundation of your case.
I see.
That timeline is the skeleton of the body of your case.
Okay.
That timeline is the same timeline, the timeline that is going to stay from like filing your application or filing, whatever it is you're filing till the end of your matter,
Right.
till trial or till there's a settlement.
Right.
And when you know that it's out, like it's inside of you, but when you know that it's been told and it's been told in a way that satisfies the legal requirements
Right.
of family court as well as does justice to your story, then you're calm.
Yeah.
Right.
Because
already there.
you're being seen, you're
Yes.
being read,
Yes.
it's out.
Yeah.
But what happens when the abuser makes a timeline of their own? That's not true. Because there's two sides to every story, and they'll say, no, that's not true. This is not the way it happened. They abused me. I'm the victim. Then what?
So, right. So usually an abuser's timeline, and this is just through experience, the victim's timeline is a timeline that could have been way longer, right? Like if she'd actually included every single thing. And it's consistent and it's quite specific. The abuser's timeline will generally be disjointed. It will generally have it'll generally like have highlights of incidents where they're constantly no they're projecting essentially, right? It generally won't be coherent. It'll be on this day she did this, and then
Right.
CIS came, and then this happened, but it won't be a story. It'll
Right.
be just throwing things at the
The
wall
wall.
to see what sticks,
Interesting. Yeah, I could
right?
see that.
Right.
Also, their timeline will change for every hearing, right? Depending on what hearing they're going. Suddenly, they'll have something new to say.
Right.
Suddenly, in their second motion, they have a new fact that they introduce in an affidavit that wasn't there in their initial affidavit, even though they were talking about that theme,
Yeah.
right? Their credibility will come across over time as very weak.
That makes sense. Yeah.
Yeah.
Yeah. It's not ironclad, therefore you can poke holes.
Right.
Yeah.
But you can't go into this self-represented. Like, you need someone to represent you in these situations, to be able to paint that to a judge and to be able to lay it all out and poke holes in the other person's case. Right.
So I'm going to be, I know that there are a lot of women out there who simply cannot afford representation. Okay. This is a terrible economy. And women that are the kind of women that, the niche that I service have been financially abused.
Yeah.
Right. And so those women are in positions where many of them they can't afford representation, or they can't afford representation throughout the entirety of their case.
Yeah.
Right. And so what I do think is that if women educate themselves and guide themselves through information, they can do a lot of the work themselves.
Yeah.
Now, definitely for emotion, you need a lawyer.
Yeah.
Right? Definitely you need a lawyer for emotion. But for a case conference or for a settlement conference, if you've had legal coaching, if you've studied, and I really, really stress this on my clients, is you need to study the law. You need to know this is a journey, and you need to know this. You need to know the lay of the land.
Yeah.
Right? And what I find is interesting is that women who are from ethnic backgrounds, new to Canada, they never complain about that. They understand that they have to struggle.
Interesting.
Be that good, be that bad.
Yeah.
They understand that it's going to be hard, but they also understand that they can do hard things. Right? I have a lot of women who say to me, oh, well, I shouldn't have to do that. My lawyer should do that. Right? And I say to them, imagine you had to come to Canada and you didn't speak English. This is family court. It's another language.
Yeah.
Right? This is like you've gone to another country. It's called FC.
Yeah.
And it's like you didn't want this visa, but it was thrust upon you. This is not the visa you were looking for, but here you are.
Here you are.
And you need to learn the language of this country, or else you're not going to make it.
Yeah. It is. I mean, we work in this world, and I'm still learning things every single day about the whole court world. One thing I wanted to touch back on, you mentioned that early COVID case, and the judge was just, not very informed. We see a lot of that. There's no trauma informed. It's all very performative. What is it about family court? What is it about this fun country of FC where people are not informed about the work they're meant to be doing?
And this is such a good question. I think, a lot of these women on my Instagram, and me on my Instagram, because I'm also following who you all are following. Right? We're all following some people. And I think that there's, you go down the rabbit hole of your own interests and passions, and what validates you.
Yes.
Right? Judges are not on Instagram.
Right.
If judges are on Instagram, they're not watching us.
Yeah.
Okay.
Right.
I'm going to tell you that right now.
Yeah.
And I think one of the things that is, a problem is that people who have nothing to do with family law come on the bench and they're like, okay, now you're going to do family law.
Yep.
And because they don't have, I mean, family law is a very difficult kind of law because there's so much legislation. There are different there's so many third parties are involved. They're interwoven into the legislation in some fashion. And so I think that judges who have no background in family law coming into family law, they are like, oh, now we're judges, yay, because it's like, it's a cherry on top of your career kind of job.
Totally.
But no one wants to actually do like 3 times more work than they were doing before they became a judge. Like they don't realize that becoming a judge actually kind of sucks. Like who wants to do you know what I mean? Like you've already been a family lawyer, or you've already been a lawyer for God knows how long. Like, and this is kind of your swan song of your career, and you have to work twice as hard, triple, like 3 times as hard. I don't actually think people realize that. I think like it gets to them, this whole like, I'm gonna be a judge, your honor, you're like, it gets to them. And then when they get there and it's not what they thought it would be, in the sense that, I know there are judges that are so incredible, and know that those judges, and like one of them, Justice Chappell, she's now retired, and it's such a sad, sad, sad day for Hamilton Court and for all of us that Justice Chappell is retired. But you knew Justice Chappell was not going home.
Right.
Like Justice Chappell did not go home. I don't know what she was doing. I think she was, Uber eating it to the courthouse. But I just cannot imagine a world in which Justice Chappell got home anytime before 10 p.m.
Wow.
Like her judgments, incredibly well researched, lengthy, but necessarily lengthy. And she's one of those lawyers that I tell she's one of those judges that I tell my clients, look her up on Cambly. Anything that was Justice Chappell, read it.
Right.
That's what that's the I the, that's the kind of law I want you to learn, because Justice Chappell's decisions, if you read the decisions, they spell everything out. They're such great learning tools. But I think a lot of these judges, Justice Chappell was actually a family lawyer before she became judge. But I think a lot of these judges are just like, they were doing, contracts law or admin law or something completely unrelated to family court. And what they bring to family court when they get there is their personal biases. And I've seen it a million times. Like, no one can tell me it's not true. I'm going to say it. Whistle blow, whistle blow. They bring their personal biases. I can tell. I can tell a judge who hates women. I can tell. I can tell when he's sitting in front of me. I don't even have to like listen to him for more than 7 minutes. He hates women.
And they get this reputation.
I can read what they're, I can always tell if it's a judge that has a family court background, and legal aid, worked for legal aid, did family law. I can always tell that.
That's really what I wanted you to touch on, is that these family court judges do not actually have to have a family law background, and I think that's really crucial. And so as a lawyer, does that, when you know what judge you're going in front of, does that change your whole strategy? How are we going to talk to them? Because you obviously need to inform them, but not, be too rough on the ego and then not have a, verdict go your way. Are you re-strategizing or pivoting based on the judge you're sort of docketed to?
So I generally don't know which judge I'm going to get unless that judge has been seized, or unless it's case management at Ontario Court of Justice level, where it's always the same judge.
Got it.
Right?
Got it.
So generally what I will say is, to your question, OCJ judges in family court are far more trauma informed, and most OCJ judges have family background.
Okay, good.
Like family law background.
Oh, great.
It's SCJ where we have a serious problem.
And that's where you have to go if you're married and you want a divorce.
Sorry?
If you're married and you want a divorce, you're going to the SCJ. So
yes. Or if there's property issues.
Right.
Right? So property issues all go to SCJ. OCJ just deals with parenting time, and support. So spousal support, child support, parenting time, decision making.
Got it.
So if that's all you got, if there's no property issues, then you go to OCJ.
Okay. Good to know. Well, that's good because they're handling parenting time and stuff. But
do you have a choice though? Can you choose?
No.
That's the thing.
No, you can't choose in the sense that here's one of the things you can do. If there's no money in terms of property, okay, and you want to go to SCJ, you don't want to go to OCJ, and you're married, you can just choose a divorce. You can choose to you apply for a divorce on top of child support, spousal support, and parenting time and decision making. And that puts you into SCJ.
Got it.
But divorce on its own, just a paper to get divorced, is just something that is not necessarily relevant all the time because, it doesn't affect necessarily your parenting time, decision making, and support.
Right. Got it.
So a lot of times, because divorce gets kind of ticked into the application box so that they can go to SCJ. And usually it's the abuser's lawyer that does that. Right? Because SCJ is often better for the abuser.
I was going to say, if they don't have this trauma-informed family law background, then they're coming in front of people that are more, corporate or tax or real estate. It's a very different situation. So fascinating.
This episode was written and created by Alex Howard and Amanda Silver, produced, edited, and engineered by RTF Productions. Make sure to rate and review our show if you loved it, and give us a follow on Apple Podcasts, Spotify, or wherever you stream your podcast to stay up to date on all upcoming episodes. Thanks for listening, and go easy on us. We're not your ex.